It looks like it's officially 1:30. Welcome everybody to another session of oral arguments online with the 5th District Court of Appeal. I'm Judge Jim Edwards. I'm joined by Judge Eric Eisnagel and Judge Dan Traver. We have one case on this afternoon's docket, and that is case number 21-1015, J. Scott Lanford as trustee versus Robin, is it Femister or Feemeister? How do you pronounce that?
Feemeister.
Feemeister, okay. Each side will have 20 minutes for argument. For the appellant, we typically reserve 5 minutes for rebuttal, but anytime you want to choose is fine. Just let me know. There's a clock in one of the boxes there, one of the windows, but I'll also try to help you if you lose track of that and seem to be heading way into your rebuttal time. As soon as that, it's hard to tell, it's yellow, but once you get down to 5 minutes, that's your rebuttal time. You don't have 5 more minutes and then rebuttal time. So sometimes people get a little confused by that. If you have something that might make noise, please turn it down a little bit. Do not turn your telephone all the way off, because if we lose you, our clerk or IT person may be calling you to try to hook you back in. So with all of that, we are ready to proceed. And counsel for the appellant, Mr. Wilkins.
Thank you. May it please the court. Today's argument really involves a fairly narrow legal issue involving homestead property. The appellee in this particular case really wants to go back and revisit a sort of a vast history of activity in this case and in prior cases, related cases. But the real issue on the appeal is very narrow, and it involves, is homestead exempt, and if does it remain exempt after the property is transferred into a testamentary trust for the benefit of an heir at law.
Before you get there, Mr. Wilkins, let me ask you a couple of quick questions about our jurisdiction.
Sure.
It looks like we're proceeding under 9.170, later in the statute, talking under subsection B, talking about attorney's fees and settling an account. Is that correct?
I would say that's true, and also reviewing attorney's fees in terms of probate administration. So there's both trust fees and probate fees here.
There is in the order on appeal a reservation as it relates to some of the expert costs. I know you take generally the position that we shouldn't be worried about costs or fees at all because from your perspective, they're not recoverable. But say they are. Is that something that would divest us of jurisdiction, or is that something that Ms. Feemeister could go after as part of a subsequent fee petition? Because it happened later in time than October 19th of 2021.
Well, I think there was already testimony at the time of the hearing as to the expert witnesses' testimony, as to why the judge did not include an award in that order. I'm not really clear if I recall, and this sort of got balanced between 2 hearings, actually one large hearing and then one post-COVID.
Yeah, I mean, we don't have transcripts, but my question though is just that one sentence. Like typically speaking, I understand probate is different, but in a typical attorney's fees proceeding, say like in a general civil case, if we saw a reservation for expert costs, I think it would implicate our jurisdiction. Here, I'm just asking you if it does, or if because those fees, expert fees, were allegedly incurred after the October 19th, 2021 cutoff date, whether we have jurisdiction of this segment of attorney's fees. Do you understand my question?
I do. I would think that the court has jurisdiction. I think the attorney's fees on those experts, that was prior to that order. The testimony was given at a hearing 1.5 years before that order was entered.
But after the time frame that was encompassed in the petitions, correct?
Correct. That's true. That's true.
Okay, thank you.
Yeah. Insofar as the issue, as the court already anticipated, our issue is not so much the amount of the fees. That's to us sort of a minor issue in the grand scheme of things. The question is not what were the amount of the fees, but where can it be paid from? And that's where I think the legal issue is sort of front and center in this particular appeal. The clearly established law in Florida is that under the Supreme Court rulings and a number of other DCA cases is that homestead is a protected asset, and it carries a very heavy burden to try to override the exemptions that exist with respect to homestead property. The court from Brevard County entered that homestead order way back at the beginning of this case. And some cases have even said that if you want to overcome the burden of that exemption, it's going to require some heavy lifting. That's in one of the cases that we cited in our brief. But once the property has been declared to be homestead, that's sort of the end of the inquiry. There is no provision in the will or in the testamentary trust that dictates that this property is supposed to be sold by the trustee or the personal representative. And as a result of that, we don't fit into the sole exception that exists when you do have homestead, but you direct it to be sold. That takes away the homestead protections from the beneficiaries who would
Counsel,
receive that property.
It seems to me that one issue here is protection from what?
Protection from creditors' claims and administrative.
Which creditors? Which creditors? Whose creditors?
Creditors of the decedent. And
Right. So
administrative
once you get to the trust, is that a creditor of the decedent?
No, it's not a creditor of the decedent.
So how would that be protected?
Well, because if you look at the Engelke case that I'm not sure it was cited in the materials, but there's a Florida Supreme Court, a Florida DCA case. This one I think is the third DCA. I've got to actually have it in front of me. That basically says that my creditors, if I'm the beneficiary, there are no creditors of Miss B.J. Shell that can be assessed against that property. The claimants here are they're basically saying the personal representative's fees, which we clearly know are the decedent's expenses, not anything to do with B.J. Shell. And the trust administration expenses also have no basis to be paid out of the
Counsel, why are the trust why are the trust expenses? Why are those considered to be? Why is that considered to be a creditor of the decedent?
Well, it's not a creditor of the decedent, but it's not.
Then why is it protected?
It's not a creditor of the beneficiary either. Again, the case law basically says it doesn't matter if it's in trust or if it's devised outright.
Is it your position that the once a property is considered a homestead, that it is always protected by the homestead exemption forever, no matter how many times it's okay?
No, what it is protected from is administrative costs of the decedent's estate and
Right.
in this case, the decedent's testamentory trust.
Why?
Well, because if you basically take away the protection, I think the only piece that is allowed under Florida law would be for the maintenance of that homestead property. In other words, the fees that are related to the maintenance of the homestead property and the fees that may be related to the
Why is the testamentary trust costs and expenses? Why is that the same thing as the estate?
Because what they basically, if it's not related to the maintenance of the exempt asset, it is exempt.
No, but once you agree that there was a transfer from the decedent to the testamentary trust, correct?
Correct. The homestead order did that.
And Shell, am I saying that correctly? Shell?
Yes.
Shell is an heir, right?
Yes.
But the property is not Shell's homestead, correct?
Correct.
Okay. So why isn't the testamentary trust costs and expenses considered a liability for the trust and Shell as opposed to the estate?
Because homestead is exempt from claims, period.
I know, but which claim? No, not any claim. No, not forever, right?
Well,
So-
it's not exempt from BJ's creditors, okay? And it's not exempt from the Kirk Foundation's creditors. But it is exempt from administrative costs of the trustee for general administrative expenses of that trust.
Why?
What case
That's
says
a
that?
very
What case does that?
Yeah.
maybe it'll help me. There are attorney's fees for work she did on the estate, although I agree it's not properly necessarily segregated, but there's attorney's fees for the estate, expenses for the estate, and then there's attorney's fees for the trust. I don't understand, like Judge Eisnagel's having trouble, how are the trust fees, expenses not subject to being collected from the property that was devised to the trust?
Well, again, I would recite you to the Engelke case, and I'll give you the citation on that. It's 921 Southern Second 693.
I've got that and I've looked at it, but it's still protecting against the testators or settlers expenses, isn't it?
Well, that case, yes, they were doing that as well. But I guess the question is, if you're protecting this asset, then how would you be, and it's supposed to be broadly administered, it's supposed to be broadly applied under Florida law.
Right,
Once
but
it's established
when
in
it's
home-
applied, I mean, y'all basically have agreed by not appealing the fact that it remains homestead property once it's in the trust, but the Constitution talks about a devise or transfer to property. It's got to be owned by a natural person. A trust is not a natural person. I mean, I know there's cases out there talking about that issue, but, and once Ms. Shell died, who's to be protected? There's no family, there's no heir, there's nothing. So all this language about broadly interpreting for the protection of the family and to keep them from being a public charge, I mean, that has no application. So again, when you talk about expenses of the trust, not of the estate, but of the trust, how is that property bulletproof from that?
I would submit that the administrative costs that relate to the maintenance of that asset for the benefit of BJ Shell will always be able to be paid from that asset. However, I don't think that for example, the appellate costs and the litigation fees that had nothing to do with the establishment of the homestead, had
Counsel,
nothing to do.
maybe if I ask it this way, I feel like I feel like you're making a point that I'm just missing. So let me ask it this way, and maybe it'll, if we walk through it as a sort of this alternative, it'll help me. What if there was no testamentary trust? What if the homestead property passed to Shell?
Okay.
And Shell held the property, sold it, either way, doesn't matter. But Shell ran up expenses, and for this purpose, I don't think it matters what the expenses are. Took out a loan, didn't pay it. Why couldn't they go after the property?
They could.
That creditor.
They could.
They could.
They could.
Okay. So why is it any different? I mean, walk me through that. Why is it any different once the homestead property that is protected from the decedent's creditors? Yes. Once it's passed to the testamentary trust, why is it still protected from every creditor under the sun?
Well, again, I think the point that I think you need to focus on is the fact that if there were other unsecured creditors of the trust, okay, let's say the trust incurred expenses for other things. I mean, I can imagine a number of things. What you're suggesting is that those creditors could come after this homestead. And I don't think that's the case.
Well,
Even though the trust had
Shell's?
creditors,
Is it Shell's homestead? Or was it the
no,
decedent's
it's
homestead?
not. It's not.
So
Again,
why can't
if Shell had incurred expenses and creditors that wanted to go against this property, they could.
Okay.
Other than perhaps some
then
Spencer.
why is that not essentially what we have here?
Because it's not Shell's creditor. It is not Shell's creditor.
Whose creditor is it?
It's the trustee's creditor.
It's
The trustee
of the
hired a
testament.
lawyer. The
So-
trustee hired a lawyer. The trustee's creditor is who's trying to get
The
paid.
Constitution says it has to be held by a natural person, right?
For the homestead
So-
exemption, no.
In other words, so in other words, you're saying the testamentary trust is both a shield and a sword.
No, I don't think it's a sword. I do think it's a shield. and this is where I think the court sort of missed.
Why can a creditor get to it if it passed directly to Shell, but can't get to it if it passed to a trust?
I can only say it the same way I said it before.
Try
This
one
is
more
not
time.
Shell's creditor. This is not Shell's creditor that's being
Okay.
paid.
Okay,
It is the
excellent.
trust that's being paid. It is the trustee's creditor that's being paid.
For the
and it's-
benefit of Shell.
Well, that's part of the argument as well. Was this really for the benefit of Shell?
Well, let me ask you this: Did it even pass to an heir? I mean, it didn't pass to Shell. Shell's the heir, not a trust. So did it pass to an heir?
It did. That otherwise, the homestead order, the court has to come to this with the order that's in place. And the order that's in place says it's an exempt asset. It's homestead, it's exempt from creditors' claims, certainly of the estate, and I would argue as well of the trust as well, except for things related to the maintenance of that asset for the benefit of Shell.
But was that order an error?
I don't think it was an error, no.
Okay.
I don't think it was an error. I mean, we're the one who filed the petition to determine homestead, and the court agreed and ended the order.
We accept
So this-
your position on this subject, and I agree with Judge Edwards. I don't think Engelke factually gets you where you need to be, but be that as it may. If we accept your position on it, does it effectively mean that the trustee, anyone who is in Ms. Femister's position as the trustee of a testamentary trust in which one of the assets of the trust is an inherited homestead property, does that mean that person always has to work for free, no matter how long the trust lasts?
No, I didn't suggest that. I'm saying that fees related to the maintenance of the homestead, costs that related to the maintenance of the homestead, those things I think are properly compensable from that asset. It's the other ancillary activities of the trust that should not be taxed against that asset. And I think that's the distinction I wanted to make. And if I can, I'd like to reserve the rest of my time.
Well, let's do this. We've asked you a lot of questions that ate into your time. So why don't I let you run on? We'll give you an extra 5 minutes. And Mr. Krasny, if you need an extra 5 minutes, you're welcome to take it. So go ahead, Mr. Wilkins. And once this runs out, you'll have another 5 minutes later.
Okay. Again, the other point that I wanted to
Counsel,
make,
is it your position that the estate and the only way it seems, the only way I can follow your argument is if your position is, and I question this, but if your position is the estate and the testamentary trust are the same thing. Is that what you're saying?
I'm saying that they essentially
because then they would be
they function together.
Because then if they're the same entity, then they would both be creditors of the decedent.
Well, I don't want to go down that road because I don't necessarily believe that's the case.
Right. So how is the trust, right? Expenses owed by the trust, how are those creditors of the decedent? They're
They're not.
creditors of the trust, right?
Right, but they're not creditors of BJ Shell.
But they're not creditors of the decedent.
Well, no, they're not, except in this case, they're sort of blended together. So you don't know, but yes, that's correct.
Well, they're not.
creditors-
And the homestead protection only protects from creditors of the decedent, right?
No,
Why?
no, it actually protects against the administrative costs of the estate administration as well.
Right. Okay.
I would say the trust administration, same
All
issue.
right. Right.
Trust
Okay.
administration.
So again, in your view, the estate and the trust are essentially the same entity.
No, I didn't say that either. Let
Okay.
me also point out, and again, I don't know if you'll have the opportunity to review it. This issue, I've already actually argued this issue before in another appeal before this court, where out of Seminole County, where the judge basically said, when that property is sold, it is not by the trustee, it is not subject to the.
So this is Trimboli, which is a PCA, which has no precedential effect, correct?
Correct, I understand that, but I just wanted the court to be aware that that's exactly the same issue we have here. The only difference is it's a revocable trust versus a testamentary trust, but of course, the revocable trust becomes irrevocable at the time of the decedent's death. So it's.
Well,
really-
counsel, there's no way for us to know on what basis that panel decided that case, and it's not binding on us.
I agree, except that it's something certainly I think that the court should be aware of, and we brought it to the court's attention as well. But back to the issue at hand, the other issue too, in terms of the reasonableness of the fees, if you want to go down that path for a moment, This was essentially a summary administration. This had an exempt asset and about $16,000 in cash. Instead, what we've seen from apparently it's because of the vindictiveness of Ms. Feemeister and her counsel against Mr. Lanford, they thought it was appropriate to spend $60,000 of $120,000 estate.
Let me ask you about reasonableness, and assume for the sake of my question that we see it your way as it relates to the estate, but we see it Mr. Krasny's way as it relates to the trust. We're missing our transcripts on the 2-day evidentiary hearing, correct?
It was a 1-day evidentiary hearing, and we had arguments later.
Okay.
Yeah.
How can we tell? You make the argument in your brief that, that Ms. Feemeister didn't properly segregate her time entries as it related to work for the trust versus work for the estate. With the transcript missing, and not knowing what the trial court looked at, not knowing how it entertained things, and also it appears that you declined the trial court's invitation to make line-by-line objections. How can we parse that on appeal as a matter of first instance?
Well, I would say that the time records are clearly in evidence. They're in front of the court. They clearly show, in fact, if you notice the billings, they're almost all from the estate. They're all billed as to the estate, not to the trust.
Well, I think they're attached to the petition, but how do we know that they're in evidence, and how do we know what the trial court considered and didn't consider?
Well, given the fact that he approved all of those fees and they matched to what was already put in evidence, I thought at least the record indicated that those were in evidence. I mean, they're in front of the court. They're in the record. So I'm not sure that why those would not be appropriate to review from this court side.
All right, well, let's do this. You've got about, you're over now, so you'll still have 5 minutes when we come back to you. And Mr. Krasny, you'll have 25 minutes with no obligation to take all of them, but you're free to if you wish. So, Mr. Krasny, if you'll proceed.
May it please the court. My name is Scott Krasny, and I represent Robin Feemeister, who's been appointed as personal representative of the estate of Mary Dillard, as well as being appointed as the trustee of the testamentary trust established under the last will and testament of Mary Dillard. It's kind of ironic that we're arguing about all of this stuff because we wouldn't be here but for the actions and inactions of Mr. Lanford.
Counsel, why isn't the estate part of this protected by homestead?
Well, that's a good question, Judge. Let's talk about that for just a second. When this whole proceeding, and I set out in terms of the statement of facts, all of the cases that brought us here to the estate of Mary Dillard. Mr. Lanford had prepared the estate planning documents for Mrs. Shell, including this Kirk Family Trust, this foundation that was the beneficiary of Mrs. Shell's documents, as well as the final residuary beneficiary of Mary Dillard's documents. The first case that got kicked off was Regions Bank filed a deck action because Mr. Lanford was demanding that BJ Shell's assets be turned over to Mr. Lanford. That kicked off a deck action. And then the next action, and that action, by the way, was consolidated into the guardianship. So the next cause of action that's relevant to this case is the guardianship proceeding for BJ Shell. BJ Shell was Mary Dillard's much wealthier sister. And Mr. Lanford did the estate planning for her as well. And Mr. Lanford actually had an agreement, an alleged agreement with the investment advisor that he was going to send the assets to. He was going to get a referral fee agreement of 40% of the investment
Counsel,
advisor.
I'm sorry, I'm not following what any of this has to do with homestead.
As we get to the estate of Mary Dillard, Mrs. Dillard passed away. Mr. Lanford didn't do anything. He didn't file the original will. My client was ultimately appointed by the court, by the guardianship court, to be the professional plenary guardian of the property of BJ Shell. At that point in time, within 30 days after my client was appointed, we petitioned to open up an estate, an intestate estate, because the original will had never been filed. It was only then.
I think you should assume that we have a command of the factual background, and I understand that both parties are casting some degree of aspersion on the other in terms of their motives. I'm concerned, I can't speak for my fellow colleagues, but I'm concerned about You've got the Constitution and the constitutional homestead protection as it relates to creditors' claims. And you've got 733-607 that talks about a personal representative taking control of the decedent's property, except the protected homestead. So if you could just address the question as a matter of law,
Yes,
as
absolutely.
opposed to a matter of fact, why should Ms. Femister be entitled to estate expenses for her role as personal representative?
Well, Your Honor, you hit on it as well. At the evidentiary hearing, and there were actually 2 days of evidentiary hearings, the testimony was quite clear in terms of the breakdown of expenses related and the time period of expenses that were incurred in this matter. So in terms of the initial actions set up to petition to get the PR appointed and the actions of the appellee in terms of caring and providing for the deceit to Ms. Dillard's house. And so once that was all set up, Judge Harris had determined that Mr. Lanford had an interest adverse to the estate and that he could not serve as personal representative. So the first thing that was done was getting a personal rep. There was no alternative personal representative
Those
designated.
sound an awful lot like facts to me. Let's hear about the law.
Okay. Once the personal representative got appointed and was serving those actions, there was still no trustee of the testamentary trust. And if you look at the homestead order that was referenced before, Judge Harris determined that the homestead vested as of the moment of death in Robin Femister as trustee of the testamentary trust. That was what the homestead order says. It vests as of the moment of death. And the twinkle of an eye, it vested, which again calls into question why Mr. Lanford didn't act. But nevertheless, in terms of the moment.
Counsel, if you could please, counsel,
Yes.
please.
Yeah.
Talk about the law. Get to homestead, please.
The homestead-
We picked up on the hard feelings between the parties here in the briefs. But if you could please just get to the legal argument on homestead, I would appreciate it.
I'm sorry, Judge. The exemption inures to heirs. The exemption inured to BJ Shell. BJ Shell was represented and had a professional guardian, Robin Femister.
Mhm.
Robin Femister, if that exemption ran to anybody, it only ran to BJ Shell. It doesn't run to Scott Lanford. It doesn't run to Lanford as trustee of the Kirk Family Foundation. The exemption inures to heirs. That heir exempt, the only person that exemption.
What about the estate expenses though?
Well, the estate expenses, and this came up not only in the expert testimony, but the testimony of the parties and broken down by time period, that the estate and trust administration were intertwined. And why? Because the will was created in the trust. I mean, the trust was created in the will. It's a testamentary trust. It was necessary to get the will admitted to probate, to get a personal representative appointed, to get a trustee who would act. All of those actions were necessary to carry out the decedent's intent, which was namely to create a testamentary trust for the benefit of her sister.
So your position is those two entities are the same, the trust and the estate, they're the same entity.
The services that were provided benefited both. And this, in other words, the work that was performed, and this was presented to the trial court as part of the record, the work that was necessary to get the will admitted to probate, to run a notice to creditors, to determine who the appropriate creditors were, to maintain and secure that homestead property. There was plenty of testimony regarding the condition of the home, the fact that it had deteriorated, the work that the appellee did, fixing holes in the floor and cleaning fences.
But if as a matter of law, and it sounds to me like you concede that a homestead would pass outside the estate, if that's the matter of law, then how could your client possibly attach against the homestead proceeds in her capacity as personal representative of the estate?
It's not attaching against the homestead proceeds. And I think Your Honor mentioned right. At the time of death, at the moment of death, it was vested in the testamentary trust. The services that were performed to get that testamentary trust established, to maintain, in 733.608 talks about the costs and fees and expenses. And I think Mr. Wilkins even conceded. I think he said, look, there's some administrative expenses and the cost and expenses associated with taking care of that home. Maybe that should come from the other assets. And so I don't, in terms of the differentiation between what role or what period of time that she was serving as her PR hat versus trustee hat, all that
Mr.
testimony.
Krasny, can I interrupt you here just for a second? It seems like there's three bundles of money we're talking about. There's money expended by the PR to maintain the house. I don't think anybody's fighting a lot over that. There's money expended or incurred as PR of the estate. That's one bundle of money. There's another bundle of money or expenses for Ms. Feemister's services rendered and her attorney services as trustee of the testamentary trust. So I don't think there's a big fight over the expenses to maintain the house. So let's focus on if it was a straight devise to Ms. Shell of the house, and that was the only asset there was, how in the world would the personal representative be able to come back against the homestead property to be paid her fees, filing fees, whatever else it is?
Well, and Judge, your question is good, which is the reason why the order under appeal, and if you look at the order under appeal, the way it's drafted, the way it is, it says that the amount that was paid to maintain and protect this homestead property, and again, the statute includes fees and costs, 733.608 includes fees and costs associated with that as well. But that money is going to be paid back to the estate, and that the court determined that in terms of the allocations of those.
Right, but you're talking about the PR incurred fees and expenses just to open the estate, to have the will admitted to probate. I mean, if you looked at those discrete expenses, how can those be enforced against the homestead property?
They were all detailed. And again, the reason what the court order says, the court order that's under appeal says, pay that money back to the estate and charge those fees and costs to the estate. And to the extent that the state is insufficient to pay those funds, that those funds should come from the testamentary trust. And the court had done that based upon the review of the invoices in the particular time periods, the services performed, including, again, and you're right, Judge, it's very difficult to determine whether I'm wearing the PR hat or the trustee hat when I'm going down there to make sure that the kitchen floor doesn't sink or that the fence doesn't fall in. Is that the role of the PR trustee? Again, those are covered by 733.608, which talks about those actions necessary to ensure, protect, including fees and costs associated with doing that.
Does that include the file specifically? Does that include the attorney's fees incurred to open the probate estate?
Well, again, I guess that was a question that was.
It's a yes. It's a really yes or no.
Well, there would be some estates, Judge, where possibly that would be a no answer. The facts of this are very specific because the court determined that fees and costs associated with getting the will admitted to probate, getting the testamentary trust established, getting a trustee of the testamentary trust that would actually take action. And again, I point you back to the homestead order, which Judge Harris entered, that says, as of the moment of death, the property vested in the testamentary trust. That's what the homestead order was entered, was never appealed. As of the moment of death, the homestead property vested in the trustee of the testamentary, Robin Feemister, as the trustee of the testamentary trust. So again, those services that were rendered from the moment, again, and it's kind of like, well, they go back in a time machine. If real estate vests in the people that are supposed to get it as the moment of death, which it does, then the actions of Robin Feemister as trustee to maintain that, it's not really a question of, well, this was with your PR hat and this is with your trustee hat. That property vested as of the moment of death in Robin Feemister.
Right, we got that. But in terms of the authority for the the probate court to say you can get the money from the trust if there's not enough in the estate. Tell us specifically where that comes from.
Well, that's
not the order, the body of law from here.
Well, the body of law in this particular case was the court having the ability to allocate fees and costs appropriate based upon.
That's what the court did. Tell me where does the probate court get that authority? Is it in the Constitution? Is it a statute? Is it a case? Is it a rule? What is it?
Yes, I mean, I think it's all of the above. The Florida cases talk about the court having, there's the Florida statute that says that the probate court has the authority to allocate fees and costs against to the appropriate beneficiaries. Same thing under the Florida Trust Code. It mentions the ability of the court to allocate fees and costs and expenses. And again, that exemption, the homestead exemption, it only inures to heirs. It would have only inured for the benefit of BJ Shell. It would not have inured for the benefit of the Kirk Foundation, especially, and again, it's ironic in terms of the argument that, well, all those fees and costs were incurred and they shouldn't have been incurred. We were just out running around. Every hearing that has gone in this case and everything that's been done has been objected to. We've been here. We haven't, every hearing, Ms. Feemister has won and everything she's done with court approval. It's not like we were running around willy-nilly, Judge. These things that were necessary to be done to protect the interests of BJ Shell.
Right, and we're not here, and Mr. Wilkins, I think, has some questions about reasonableness. That's not what we're talking about right now. We're talking about how do you get it from the homestead property that's protected from the creditors of the decedent, which should include and typically does include protection against the expenses of administering the estate, doesn't it?
Well, generally, when you're heir, again, the question is who's claiming, and you talk about the sword and the shield, who's the one who has the right to claim this is exemption from the claims of creditors? And it's the heir. The heir is the one that has the exemption inures to heirs. Article 10, Section 4B of the Florida Constitution said that exemption inures to heirs. It inured to BJ Shell. And so BJ Shell—
The Constitution says it has to be a natural person, which you could certainly have contested the order declaring it homestead property. I know there's cases out there that seem to skip over certain parts of Article 10, Section 4, but you didn't appeal that. So it's homestead property.
Well, and exactly, and much like in the Mullins case, and I believe that the Mullins case was determined by the 5th DC. I think you guys determined the Mullins case in terms of the homestead order and the significance of the homestead order and title. It was very important to be able to determine or have some ruling from the court so that we could ultimately get this property sold. This property needed to be sold for the benefit of BJ Shell, and the trust and the Florida Trust Code clearly authorized the trustee to have the discretion and authority to be able to sell this property. It's not like you got to keep this property forever. And Mr. Wilkins kind of makes the argument, well, you know, this exemption, once it's there, it can never go away. You can never sell it and you can never get any bills or you never get any expenses. And
Well, counsel, I mean, that, you know, if to the extent that your opposing counsel is arguing that, you know, that I'm sure the panel will decide whether we think that's correct. But I have yet to get a clear answer, at least that I can hear, that I've heard, as to, you know, why costs and expenses of the estate can be recovered from the homestead proceeds. I look, you know, it seems to me that there's a separate argument relating to the trust. Okay. But if I recall the record correctly, the trial court separated them out, right? So as for the portion awarded to the estate, why does homestead not protect the homestead exemption? Why does it not protect that portion of what happened?
Once again, I think that in the mortal words of Cool Hand Luke, we're having a failure to communicate, and that might be part of my fault. But again, when the homestead property, when she passed away, because it was Mary Dillard's homestead and invested in the twinkle of an eye to the trustee of the testamentary trust, it was always part of the testamentary trust. The question is, as of the moment of death. So the
okay, stop. Yes.
Yeah.
All right. You don't need to say the twinkle of the eye thing anymore.
Okay.
We got it. Okay. All right. So far I'm following you. Proceed.
Okay. So from that moment going forward, and again, there was testimony as to each line item almost in terms of everything related to our invoice.
No, I don't want, no, we're not to that yet. You're skipping over a bunch.
Okay.
Okay.
So
we don't need to talk about the reasonableness of line items and things like that. I'm just saying, once the property transferred, was it not protected from the creditors of the decedent and also the estate trust costs, the estate administration? Yes or no?
In a normal case of the situation where you're talking about an exempt heir who's claiming that distinct and separate from a creditor, that exempt heir has the right to claim that exemption. The exempt heir would be, in all of the cases that are cited, Those cases deal with an exempt heir who said, look, I was supposed to get this house. My mom or my dad left it to me. And it's exempt from the claims of the decedent's creditors because it passes to me free and clear of the claims of creditors. Once that property hit the testamentary trust, Robin Feemister is the trustee of the testamentary trust. And again, that happened at the moment of death. Those costs and expenses, the court had the right to look at what those fees and expenses were and allocate them between whether they were an estate expense or a trust expense, make that factual
But
determination.
counsel, that, I mean, I'm trying to get a clear answer so that we can reach the right decision. But I mean, that seems like a very conclusory statement that you just made. Help me out.
Again, I think that in terms of the personal representative of the estate, if the personal representative of the estate and the trustee of the trustee are doing two separate animals, but in this particular case.
So you're saying that in this case, the difference is in this case, the estates, the costs and expenses for the estate,
it's the time
can be charged to the homestead proceeds because the homestead was transferred into a testamentary trust and not directly to an heir. Is that what you're saying?
No, I'm saying
Okay.
section 608, which says, hey, you, whether you're the personal representative of the trustee, whoever the heck you are, you've got an obligation to do this, to maintain, protect, ensure.
Hold on. Seven. All right. Now I'm following you. So 733.608.
That's correct.
Okay. Hold on. Whoa. Hold on.
Sorry.
That requires a lien.
It requires a debt. 733.608, and Robin Feemister was the guardian, the plenary guardian of the property of B.J. Shell.
Maybe I misread the statute. Are you telling me that this statute does not require a lien? Maybe I'm thinking of a different statute.
733.608 talks about expenses incurred and who takes them in terms of getting. It doesn't require a lien. What the statute says is a debt. The debts associated with maintaining.
Hold on, can I read?
Sure.
6083?
Sure.
If the personal representative expends funds or incurs obligations to preserve, maintain, insure, or protect the property, homestead property, referenced in subsection 2, the personal representative shall be entitled to a lien on that property and its revenues to secure repayment. Is there a lien in our record?
There is no lien in the record, Judge, because many of those things, and again, when she took possession of that protected homestead, again, it hadn't been determined to be protected homestead yet. And there was, in terms of, and again, the statute goes on to say in subsection 3A, it says that on a petition of the personal representative or other interested person, and that's clearly Robin Feemister as PR and trustee of the estate, as the trustee of the testamentary trust, for B.J. Shell, she was the guardian for B.J. Shell. And this is exactly what's been done. We presented all those fees and costs consistent with the statute and said, hey, probate court, we're entitled to have the estate be reimbursed for those costs and expenses that were done, which, by the way, Mr. Wilkins and Mr. Lanford have objected to every step of the way. It's not
So is it your position that we can read the statute as allowing a lien but not requiring it? Is that what you're trying to argue?
It's not a question of a lien. There was no lien necessary because it was already an asset of the trust. The question is whether the debt and the costs and expenses associated with that are appropriately paid from some source. And they should.
What do we make out of subsection B if you continue to go on in that statute, which talks about how your client may enforce payment of the debt? It doesn't seem anywhere to suggest that she can get that out of the sale proceeds, does it? Talks about foreclosure, offset on revenues.
That has to do, and again, that's again, Judge, the person's having an interest in the protected homestead. That's not Mr. Lanford. That's not the Kirk Family Trust. The only person that would have any interest in that homestead was B.J. Shell. She was the only one to which the exemption inured. She was the only one that would have any rights to any of the use of any of those dollars in that trust or assets that were in that trust. And the trust clearly gave Robin Feemister the authority and the obligation to maintain, protect, insure, and
Mr.
sell.
Krasny,
Yes.
Mr. Krasny, the way you're describing for this case, the homestead exemption, homestead protection is zero. Zero.
Well,
How is it protecting the homestead property that in the twinkle of the eye was transferred to the trust from the expenses of the decedent's estate? Not for maintaining the property. I'm not talking about that. I'm talking about anything the estate incurred other than simply maintaining the property or selling, the expenses of selling. I don't care about that. I'm about opening the estate, admitting the will to probate, all those other expenses.
all those expenses were broken down by time frame in the invoices to the court, to the trial judge, the judge having heard all of the testimony related to it.
I'm not talking about the amount of them. I'm talking about how are they enforced? How are they paid from the proceeds of that supposedly protected homestead property? The
Because
protection is zero.
Well, no, not necessarily, Judge, because obviously in most cases, the fees and costs and
Well,
expenses.
it's either protected, Mr. Krasny, it's either protected or it's not. And you're saying they can get paid from that, which says it's not protected. It's either homestead protected property against the decedent's estate, not counting the expenses of maintaining. I'm not talking about that kind of stuff, but the normal expenses of administering an estate, you say it's not protected against that.
No, Judge, and if I gave you that impression, that's not what I'm saying. I'm saying in terms of this particular case, in terms of the actions that were taken by the personal representative, the testimony, even the testimony of the experts, established that the work that was performed by the personal representative, almost every bit of it was done for the administration of the trust and the protection of this homestead property. And so those fees, that's a question of fact. And again, that was presented. It wouldn't necessarily always be zero, Judge. That's not, and I'm not trying to suggest that this is somehow some.
I think Counsel, we're not really asking you about right now about the costs for the trust. We're asking you about the costs and expenses awarded to the estate.
Well, again, I think that the probate court was breaking down those portions along with determining in some 733-608, which is the reason why the court said, look, to the extent that you have these fees and costs, they should first come from the estate assets first. That's the reason for the reimbursement to the estate for the costs and expenses. That's what the order provides. Pay that money back to the probate estate, pay your fees and costs and expenses from that. And to the extent that that's insufficient, I've determined that the costs and expenses and fees that were associated with the testamentary trust be paid from the assets of the trust.
Can I ask you just, I know you're out of time, but just one more question about a different topic area. You've sought appellate attorney's fees for trustee work under 736.1005. Your motion doesn't address at all a series of decisions from the 4th DCA and 2nd DCA that basically suggest that's exclusively the trial court's province. Would you address that, please?
Absolutely. And Judge, I actually presented that and I sent some supplemental authority in terms of the probate stuff. I agree. It wouldn't have necessarily been a province of this court. It would have been the probate court, which is exactly why the probate court did decide in this case that having a trustee.
No. Your appellate fees for this, like the actual thing that you're doing right at this minute.
I think I phrased it in the alternative, and if not, to remand it back to the court to enter the appropriate amount of the fees that were appropriate.
Mr. Krasny, if you'd like about 15 or 20 seconds to wrap it up, if you can do it that quickly, fine.
Yes, again, there's been a lot of water under the bridge. This is not really necessarily the very narrow legal argument Mr. Wilkins would like you to believe. The primarily reason because his client is not an heir entitled to the homestead exemption. So I just hope the court will take that into account too.
All right, thank you very much. Mr. Wilkins, you're up and you've got 5.5 minutes. And if you need a few more seconds, nobody's gonna.
I will make it quick. Again, I think the point that the court's making is well taken. It's really the province of the personal representative to establish the reasonableness of the fees that were related to the estate administration. Those are not compensable from the homestead. The other issue that Mr. Krasny sort of brushes over, and this goes back to his twinkling of the eye thing, is that Mr. Lanford was the nominated testamentary trustee in the will. So at the moment of death, and the moment that will was admitted, it was Mr. Lanford who was essentially the title holder to that property as trustee for Michelle. It was only subsequent to that time that they basically petitioned to have him replaced, and that's what precipitated the prior appeal. So I think the argument that somehow she's acting as trustee and as personal representative when she was not the trustee until almost the end of the creditor's claim period, after she had already incurred a good bit of those expenses. I think the court at the very minimum needs to disallow certainly the payment of any of those administrative costs that relate to the estate, the attorney's fees related to the administration of the estate, all the way through. And I'm not even convinced, frankly, that the appellate fees that were included in the award, that those are not normally administrative fees as well of the probate, because what we were appealing is the enforcement of the will that appointed Mr. Lanford the trustee. And so I think those, once again, those had nothing to do with the protection of the homestead property and are not properly compensable from the homestead proceeds.
But as to the trust,
I think they're not compensable by the trust either from the homestead proceeds. Those had nothing to do with the protection of the homestead property for the benefit of BJ Shell. And I think you blow a huge hole in the homestead exemption if you basically take the position that trustee fees, once it's transferred into the trust, then those can be paid out of the homestead. I just don't think that's really the intention of what's been the homestead law in Florida for a long, long time, as well as the fairly broad reading that the Supreme Court gives it, as well as these other cases where there is not a natural person. The trustee is not a natural person, technically, the trust isn't. But you see the homestead exemption still applied in cases where the homestead is owned in a trust. So again, I think the issue of the natural person comes in when you're trying to deal with a creditor's claim of that heir, not the creditor's claim of the administration of the trust or the administration of the estate.
my colleagues have any other questions? Okay, well, thank you both very much. It's a very interesting case and we will be adjourned.
Thank you very much, Your Honor.